on the topic of Motor Vehicles Act. Friends, when we speak with the Motor Vehicles Act, this is again a part of general insurance and is considered to be as a miscellaneous insurance under the insurance law. And we also see this motor vehicle insurance covers the risk that is arising out of the use of motor vehicle. I am taking this word, please underquote the word use there. Out of the use of motor vehicle, and like something like where if I am using a car, or if I am using a truck, or if I am using a lorry, bus, etc., etc., etc. Where if on the use of that motor vehicle, if the loss is caused to oneself or to that of the another as a resultant of an accident that would have occurred in, then the insurance company would become liable. So what we see here is this, my friends, why this, in the motor vehicle insurance is, it has brought in the area of miscellaneous insurance for the reason that it has taken in the part of or to the side of general insurance, because this is considered to be as a separate set of insurance in itself. It is not that way of insurance unlike life, fire or the marine insurance. It is not this like of the same like of those insurances. And the another major difference that we can make here in this kind of insurance is it is a compulsory insurance wherein the owner of that vehicle or any such person who happens to hold an interest in that vehicle, and if he is using that vehicle, then he is mandatorily required to take an insurance. That's how we see, as soon as you take a car or as soon as you take a bus of yours, as that is a new bus or a new car, you are compulsorily required to take insurance from any appropriate insurance company or required insurance company. So it makes a mandate on your part to have an insurance, and without that insurance the vehicle or the motor cannot be used with. So that makes us to understand the differences of which we can see as how the motor vehicle is different to that of the life, marine or fire insurance. And we can also see this is an insurance which also covers the property. That could be, when I say the property, it could be your own vehicle, or that is the damage caused to that of the property, or to any bodily injury which is a resultant of that of the accident, or includes a medical expenses on the one side. So also it includes all those expenses what you have incurred in the legal proceedings of having initiating the claim against the insurer or against the insured, where if it is personally, and also friends the losses what has been incurred to you, that is to your one's own income. So the extent of the scope of this that is this motor vehicles insurance is something very vast comparing to that of other insurances. I don't say, my friends, this is also a contract of indemnity. I don't say this for the reason that, of course, to some extent we may say that as to the extent of loss you are going to be compensated, but still the extent of loss what I am going to be compensated may not be equal to that of the premium that what I am paying on that of the insurance when I take the policy. Suppose, say, in case of fire insurance, see, if I take an insurance for 5 lakhs of rupees or 50 lakhs of rupees for that matter, then the premium is going to be decided on that of the 50 lakhs of rupees. But when it comes to the motor vehicle insurance, in case of motor vehicle insurance, the premium is not on the basis of that what is the maximum amount you could get incurred with, or you could involve in the accident. What is the compensation that you are going to pay upon with? It is not that. See, even where there is a meager premium that you have been paid on that of the insurance, but still tomorrow when it comes to the claim or awarding the claim on the insurance so made, then the amount can go exorbitantly much higher than what we have thought with. Suppose, say, if I'm traveling in an aeroplane whereby there is an accident causing injury, severe injury to me, then what happens there is that maybe my insurance claim may run sometimes, maybe it may run in thousands, it may run in lakhs of rupees, or it may even go to the crores of rupees. And the insurance premium or the compensation what is being payable on that of the premium with one person to that of another person may not also be the same. So in that way I say you this, my friends, though we say to some extent it may covers that what is the loss, and it could be the compensation can be made for that of the loss what has incurred with, but ascertaining of the compensation is not the same as in case of other forms of insurances. So that is the way which we see how this motor vehicle insurance flows with or carries with. So what we can understand here is this, my friends, it covers all those losses. As I then said to you, property is as a property, or a damage to that of the property, or any injury caused to that of yourself or to that of the third person, or you may, in the course of accident, you may require to have a medical assistance for you. So for that medical assistance, you may have incurred certain amount of money, or expenses could have incurred. So the expenses for that of the medical expenses, and also the legal proceedings to initiate to recover that money can also be compensated to you. And during the course of this medical treatment which has been provided to you, you may lose your own earning. You may incur certain liability because you would have stayed there on the bed and you might have lost certain earnings. Even that can be considered under this area. So we shall say that in every cases of motor vehicles insurance, we see there are two kinds of risk that are covered with, two types of risk that is covered with. One risk is to one's own property or damage to that of the property, that is to the vehicle which is involved in the accident or on which the insurance is being taken with, or also, my friends, the medical expenses. A part of this, it is now for me. If I have incurred in medical expenses because of the accident in which I was driving my own vehicle, then I am entitled to. Vice versa, on the other hand, it is not only for me, but even to the other person for that matter. That is, if I have caused an injury to the other person, the insurance company has to bear the loss of the expenses of that person too. And in the course of this, any legal proceedings has been taken with, that is also so. That is also can be brought in. So that is how we see that there are two kinds of risk which is going to be covered under one insurance, and this kind of insurance is also called to be as, that is the entire kind of insurance I'm speaking, is also called to be as an auto insurance, and we call it popularly as an auto insurance or referred to as an auto insurance. And if you just go down to the background of this, as how did this insurance started with? Friends, this is an insurance for the first time. It was started in England way back in the 1894. Till then, they did not have a concept of insurance here. Or the concept of motor vehicles insurance was not being made. And for the first time in 1894, the insurance company came forward of giving an insurance to the car, not to the other vehicle. First insurance was made to that of the car, and later on it developed, and one after the other all those motor vehicles was brought under the umbrella of this area of insurance. And if you look at the third party insurance, this third party insurance was recognized from the year 1930. So the option was given to you, that is, when I have a vehicle driven by me or by any of the employee for that matter, then that vehicle can be insured in two ways, that is, one for my own damage and for the damages of the third party. So in this way, my friends, in 1930 we see that the first time the third party insurance was also got recognized by the same of the accident what could have incurred in. And if you look at the Indian scenario, in India, the act was passed, that is called as Motor Vehicles Act was passed in the year 1939. So from thereafter, the development of motor vehicles was started with, including all those vehicles with. Let me also say what are all those vehicles. But before that, I would like to quickly draw your attention to that of the principles of this motor vehicles, because we always say motor vehicles accident, that is motor vehicle insurance, is quietly different from that of other insurances. So in that scenario, if you look down, what are the principles of the insurances? Because still we call this to be as an insurance. All those principles of insurance is equally applicable here. Like, that is utmost good faith, the insurable interest. But when I speak to you with the insurable interest, I have a limitation to this, and have a change in discussing with this with the other part of insurances. Like, when it comes to the question of insurable interest, generally we say the owner of the vehicle is the person who has an insurable interest. Or we can, in a general term, that is in a common language, if I am to say, that is taking on the business line, that is insured, that is who owns a vehicle and who possesses his name in the list of vehicle, is a person who has an insurable interest in that. But otherwise than this, my friends, we also see sometimes the other person shall also have an insurable interest in this. Like, say for example, the driver of the vehicle. I might be a owner of the vehicle. I have an insurable interest. But what does the driver have any interest in the vehicle? But still, my friends, the driver of the vehicle and even the passenger of the vehicle do also have an insurable interest. You would have come across in a scheme made out by the government of Karnataka, that any person who is traveling in a long distance of more than 50 kilometers shall be covered with an insurance under KSRTC. So that the person is required to pay 1 rupee of his premium, that is as a premium on that of the ticket what is purchasing to travel with. Of course, the ticket was used to be collected. Of course, it is in the form of compulsory, which they used to collect compulsorily of 1 rupee for the travel what it does with, and that 1 rupee would be paid as a premium on behalf of the company. That is, in case of any accident, the passenger is also entitled for the compensation. Now look at this. When I'm giving you this example, it is not that the owner of the vehicle, maybe the KSRTC or the government of Karnataka might be the owner of this, or what you call it as KSRTC company might be the owner of this, but still a passenger who is traveling in this bus is also equally having an insurable interest by paying that 1 rupee of premium for the travel what is undertaking in that bus. So we say that the scope of insurable interest in respect of motor vehicles have also extended away and said that it includes the driver, and also a passenger who travels in this bus or in that vehicle is equally entitled to have an insurable interest. This is one another requirement we see. Likewise, we see here too, we see the principles of indemnity is applicable, subrogation is applicable, and also the proximate causa is also be looked in while having deciding the compensation or honoring the compensation what is payable on that of the insurance. So subject to the satisfaction of all these things, my friends, we shall see that the insurance is going to be effected. Now, what are the types of insurances you come across with? What are the vehicles which are covered under the motor vehicle insurance? See, there are different types of policies which can be made, of course, to this extent. But before I go with the types of policies that you could effect with, first let me speak to you with or discuss to you with, like, what are the vehicles that is being covered under the Motor Vehicles Act. Friends, it is a common classification if you look upon with that, what are the vehicles that could be brought under the ambit of this motor vehicle insurance is that, see, we say private vehicles or private cars, motorcycles, and also commercial vehicles. We categorize in this way. And even in that we go on categorizing like this. Suppose if I am saying a private car, So a private car may not be just used for the purpose of me traveling from one place to another for maybe to attend the function or to get into my office or so. Sometimes this private car is also used for social work, or it might be used for domestic purpose, or sometimes we also use this for the pleasure of ours. I'm not saying pleasure of ours is in the sense not which is unlawful in nature. That is not I'm going for a race on my car. It is not that. That is especially the people who are happen to reside in the cosmopolitan cities. We come across that every weekend, fed up with the traffic, fed up with the people junction, or fed up with the pollution in the city, people rush down to the other picnic spots or the hilly areas to have a pleasure of them. So if any vehicle is used for this purpose, then it should be covered under the ambit of the motor insurance. So we say this in a simple way. That is the reason why we say in this way, any social, where a car is being used, vehicle is being used for the social purpose, domestic purpose, or even for the purpose of pleasure, then it should be brought within the ambit of insurance one. Or it could also see that the vehicle can be used for your professional purpose or for the business purpose too. It is said to be equally good enough for the purpose of availing an insurance on that of your vehicle. So when I say private vehicle is an inclusive of all these things, even where if it is carried with, it is not just for one event that you are taking with, it includes all these things, and if that is being made, then fine, it is liable to with. And when it comes to the motorcycle includes motorcycle with or without side car. When I say side car, probably if you look at some old movies, whether it is Hindi or Kannada or any other languages that of you are looking with, you could come across that a vehicle which is attached with, that is a two-wheeler, a bike or a scooter, which is attached with another vehicle, a small pillow, wherein you are required to sit in that. So maybe usually, because then it was so, that is, if a family has 3 children, husband and wife would sit at the back and the child will be placed at the and attached to a vehicle, attached small vehicle which is to that of your two-wheeler. That's what we call it as sidecar. So I mean, this kind of, we see sometimes these cars in, especially in Western countries, we have a vehicle, motorcycle which has a doors also. So it includes all those things. That is why we say that when I say motorcycle includes a car, that is a cycle which is with the sidecar or without the sidecar. It could be an auto cycle, and it could be mechanically driven or pedaled cycle also. Mechanically driven or pedaled cycle also, but it should be an auto cycle, a motor scooter, and also, my friends, your 3-wheeler carriages. All this would fall under the ambit of motorcycle. And it also includes the commercial vehicles. That is, having distinguishing these two, which also say that this the same can be also included by way of commercial vehicles. Like when I say commercial vehicles, there could be a goods carrier. And even in that goods carrier, the goods carrier may be private vehicle or it could be a public vehicle. Then we can see that trailers are tilters. We can see upon with that, or passenger carrying vehicles, passenger carrying vehicles, something like bus, or it could be airline or hotel buses, or a mini buses, or so on and so forth, etc, etc, etc. So passage carrying vehicles are also brought under these areas. So all these things are brought under this area, and all those vehicles can be insured with. But one small exception I would like to put you here is that the question always comes to is that a tractor used for an agricultural purpose, just for an agricultural purpose. So now see, when I'm taking the tractor on the road and the tractor has been taken to my field, agricultural field, and when I'm using the tractor for an agricultural field, if any accident results out of it, then does it comes under the ambit of motor insurance? Says no. See, there again we have to make a distinction. When the accident has occurred with, whether the accident was on the road or whether the accident was caused by the collision of two vehicles, or whether the accident was just on the in a agricultural land where I was using it or so. Usually in rural areas you may come across with this. That is, people after having a long work of time, they go take the shelter of the tractor, and underneath of the shelter, because it will be normally a little height, if they go down the underneath of the tractor and they take a small nap. Suppose say if towards incident happens, then can you say that it is an accident caused by way of motor vehicle? Says no. That is the reason why, my friends, here it says that is, in case of tractor when used for agricultural purposes, then that can be not brought under the coverage of the vehicle insurances. So except of this, my friends, we can say this, yes, the tractor can also be a part of the vehicle for obtaining an insurance. And what are the different types of policies we can come across with? Friends, when it comes to different types of policies, there are three types of policies which is recognized with. Three types of policies for the entire motor vehicles insurance. One is act only policies. The second one is third party policies, and the third one is comprehensive policies. And of course, to an extent, I can say the first two insurances, act only policy and third party policy, is compulsory in nature. It is mandate in nature. You have no other option. Before you could ply your vehicle, before you could take your vehicle on road, or if you want to take your vehicle, if you are bringing it on road, fine. If you are just keeping it as a showcase piece, no issues for you. But once when you take that vehicle, other than that of a display, if you are not just keeping it for a display, once when you take it outside, when you are taking it on the road, it becomes necessary for you to have compulsorily an insurance on that. There should be an insurance. Unless where insurance is there, you cannot take that vehicle on the road. This is the restriction. But however, we see that by and large, if you look upon with this, when it goes with the types of insurance, we see that this act only parties, that is only to the parties or policies are concerned. If you go with this, my friends, as I then said, as I was discussing to you just now, it is compulsory in nature. The owner is required to abide the provisions of the Motor Vehicles Act. Then it also compels upon covering all those property and life of the person, that is the risk on life of the person, of the property, and to that of his employees who are engaged in the vehicle. This is more particularly, see, when I say act of the policies, when I say the kind of policy that what it covers with is, this is a kind of an insurance where the insurance is usually obtained to those vehicles which are which are used for the carriage purpose. See, many a times I might be, suppose say I am a company owner of ERL, just for an example I am taking this. I am a company owner of ERL. When the company owner of VRL, when I'm the company owner, I might be having so many number of buses. I might be holding. Or if I'm a proprietor of a buses, maybe to an extent of 100 buses I'm owning with, maybe Sharma Transport, Jabbar Transport or something like. Then what is that I'm seeing there? Though I am the one person there owning all so much of number of buses. Now, when I'm owning so much number of buses, is it possible for me to run all the buses by me alone? No, I have to employ certain person. So when I have employed certain person, the property, that is such person who is being deployed for driving the vehicle should also be covered under the policy. That is the reason why we say that this is a kind of a policy which covers the property of, that is the vehicle itself, and the life of the person, that is, it could be the owner himself or the life of any employee who is engaged in the business of this vehicle or who is engaged to drive out the vehicle. So this is a kind of a risk which is to be covered in together with all those persons. And friends, the same scenario or the same thing we can also come across in cases of under the Act of Workmen's Compensation Act 1923. The same is there. But what the difference we can make out between workman compensation is that is during the course of work, that is if it is a case of a factory or if it is a case of an industry, if is in the course of work, if is being injured with, then under workman compensation is entitled to. But when it comes to any plying of vehicle, maybe a transportation business I am doing with, and in that transportation, if I am incurred with an injury or involved in the injury, then I am liable to be compensated under this area. So what we understand here is this, my friends, this is a kind of an insurance. It is a kind of an insurance. I repeat this, Act only policies is a kind of an insurance which covers not only to that of one person, but also it covers the risk of the third parties. So this is the basic difference we see, or understanding, not a difference, the understanding we see in case of Act only policies. The second kind of the policy is third party policies. Third party policies. See, third party policies. See, this is a kind of a policy, again, which is, as I then said, it is mandatory. Whether it is your owners, whether the property is being or the vehicle is being used for your own purpose or not, whether you want to cover the loss of damages that is going to be caused to the property of yours or what, it becomes immaterial. But it says that is once when you take the vehicle, that vehicle to be taken out should be at least should have covered the third party insurance. So that when the incidents, when the eventuality takes place with, then at least this policy could get some compensation to that of the person who is injured with. So what we can understand here is this, my friends, that is, it says like this, when you take up the policy, if you are interested in covering out your own property, that is damage that could be caused to that of your own property, but if not so, if you are interested in, then you should at least have a third party insurance. So that when you have a third party insurances, it could happen so that, my friends, that is the person who involves in the accident could be compensated, and moreover than that, the value of the insurance would be also, even the premium that you are going to pay is very less on this, but the value of the insurances, that what you are going to incur in if no insurances, can be minimized by you for from that of the certain amount. That is the reason why it says that is insurer, when the property is insured, when the car or vehicle is insured, we see that if the same is not there, you might require to pay a higher value for what the loss is going to be caused. Suppose, say, in the course of an accident, if a person dies and the value of that person is estimated to an extent of 5 crore rupees, then is it possible for me to pay 5 crores of rupees? Maybe my vehicle is a small vehicle which have taken a second-hand bike for 5,000 rupees or 10,000 rupees. Now, if the accident is caused by me, by that vehicle which involves 5 crores of rupees, probably I would be thinking like this, I could have bought a Mercedes-Benz, 5 Mercedes-Benz there. So look at this, or 6 Mercedes-Benz, more than that for that matter. So when I look at this criteria, it is always becomes difficult for me. So what the insurance says is this, my friends, that is when the claim becomes higher in the value as against you, to minimize that or to minimal the claim that what could be happened, at least the third party insurance would come to you in your favor of this. So insurer is liability to pay the cost and expenses of what you are going to incur with. That is, insurer is going to require to pay. And especially in private cars for that matter, my friends, there are two different covers are available even under third party insurance. That is, where if any insurance that is under third party, if the loss is caused by way of fire or if the loss is caused by way of theft, you can cover with, especially in cases of private insurance, private car insurances. You can insure a part of that, that is loss caused by way of fire, loss caused by way of theft, one, or it could be both that the third party insurance and also includes fire and theft for this. So in this way you can have an insurance. And the third one comes, this is the first one, second one, and the third one comes is comprehensive insurance. See, this comprehensive insurance means it is an insurance which covers the entire claim under one unit. That's why we call it as comprehensive. Comprehensive is, that is, completely, taking completely or covering only. So if I am to take a risk, see, suppose if I am taking the risk act only policies, what is that I am taking? The insurance covers myself and also the employees of me. But when I take the policy of comprehensive, see, this comprehensive policy includes both the third party insurance and also the insurance coverage to that of my vehicle. As I was then saying to you at the introduction, see, this is a kind of an insurance which is provided for the loss of your property, that is the same vehicle, or it covers out the property, it covers out the risk of damage to that property, or it covers out the risk of you incurring an injury from out of the accident, and also it covers a loss which an other party may incur with. So it covers the entire thing, and that is the reason why we call it to be as comprehensive insurance. That is, it covers the losses and damages that could be caused by the vehicle to any other person or to himself. And what all that is going to be generally covering with? How do I say? Damages to the car or parts of the car or to the body of the car, or the removal charges and repair charges which I could include or involve in the accident, third party liability, cost and expenses that is going to be incurred with that of the risk that I am taking to with, or the medical expenses. All these things would be covered under this. And to some extent, if your vehicle, the company would say, and of course it has become a mandate also by 2019 and of course 2015, that is, every vehicle you take in, new vehicle, at least for the term of 5 years, it shall have the comprehensive compulsory insurance. Compulsory, that is 5 years, at least for the period of 5 years, because so that your vehicle is new. And if in case of loss, you may have to incur a burden, so that may take away like the value of what you have invested in. And it may be, and the object of the insurance would not have achieved if you don't do this. So that notion, they said that at least for the 5 years, and of course when it comes to the insurance sector, the company itself would say no, that your vehicle should be insured for 15 years. That is, 12 years I believe. I'm not very particular with the number of years what it is. That is, maybe for 12 years if I'm right, the company shall compulsorily go with the comprehensive insurance. That is, you have an option for going with the compulsory insurance. Later on, it is only third party insurances, probably. I believe with the number, I'm not very correct with the numerals, but still we can see that this could be an optional after a certain period of time. But when it comes to these two are compulsorily required. But holding compulsorily, you can even opt for this comprehensive insurance also. So in this way, my friends, we can say that the comprehensive insurance can be costly. So these are the three types of insurances. These are the three types of insurances, that is act only policy, third party insurance and comprehensive insurances. This is how we see that insurances can be made. And what are the factors that influences the payment of premium? how the premium is going to be decided by the company, what all that it looks with. See, when it comes to the ascertaining of premium, the first thing is that they look is the type of vehicle. What is the type of vehicle you are holding with? Whether it is a commercial vehicle, whether the usage of that vehicle is for your private purpose, or two-wheeler, or kind of vehicle it is, etc., etc. So these things they are going to look at. That is the type of vehicle. The second one is the physical condition of the vehicle and the driver. How long the vehicle is, how old the vehicle is. That is more particular the age of vehicle it is. What is, how it is, how it is being, how the fitness is being made on the vehicle. Now in Bangalore we see this, in Karnataka we see this. If those vehicles, even a private vehicle for that matter, and of course Motor Vehicle Act 2019 has come up with this, which says this, that is those vehicles which have completed the age of 15 years, that is if it has served for you for the 15 years, then for running the vehicle you have to go to obtain with the concerned authority or concerned department with a fitness certificate to that. So unless you obtain a fitness certificate on that of the vehicle, you are not entitled to drive the vehicle on the road. So now we see this, that is the capacity of the vehicle, the age of the vehicle is also equally considered with. Apart of this, we shall also see who is the driver, what is his health status, what is his understanding, does he suffers from any disability. All this is also be to taken care with when you are giving a vehicle. So what in a way I can say is that the physical condition of the vehicle and the driver is also taken in while deciding the premium payable on it. That is whether you yourself is driving the vehicle or whether you are giving it to a driver or there are different drivers who would be driving the vehicle or not is also a criteria to fix the premium. And the third criteria is the geographical area in which you are driving with, in which the vehicle are going to be used. See whether the vehicle are going to be used in more populated area or whether the vehicle is going to be used in metropolitan cities or whether the vehicle is going to be used in hilly areas or whether the vehicle is going to be used in rain-bound areas or whether the vehicle is going to be used in the hilly areas which are very slippery. See, these things, etc., etc., are there. So, the geographical area of which the vehicle that you are going to normally use in also decides the premium that what you are going to be payable on that of your vehicle. So, all these factors would make it necessary to fix the premium on the vehicle. See, when I say that the insurance what I am taking down to the new vehicle of mine, because now Kia has come, where new vehicle Kia has come. Now when I am taking an insurance on that of the Kia in Bengaluru, and the insurance what I take for the same vehicle of Kia of the same brand, same thing, at the same what is that you call specification which I am taking in some of the Himachal Pradesh areas or in the area of Jammu and Kashmir where I am to drive it the IC land, then the insurance varies with each other. The insurance may not be the same of what a person takes an insurance in the hilly area, that is in the place of Jammu and Kashmir, and the same thing would be there as in Bangalore. So there would be a differentiation in this. So on the basis of this also we see that, my friends, the insurances are going to be taken. And once when insurance is being taken on the motor vehicle, what are the losses that is going to be covered here? See, loss or damage by way of accident, loss or damage by way of fire, or loss or damage caused by way of lightning, theft, malicious act, or even natural disasters. All these things can be brought under the motor vehicles, that is claim of yours. So it covers all these things. And when it comes to the third person, third party liability, where if that third party has incurred an injury or resulted into death, or it might have also resulted into the damage to that of the third party or property of the third party, then that is also been brought under this area. And it also covers any sort of medical expenses for myself or to that of the third person. So it covers the entire area. And what is not covered under MVC? Friends, when we speak with what is not covered under MVC, that is motor vehicles claim, there are certain exclusion which has been given to you. Now I take a new vehicle, having taken a, suppose say I take a Swift car. Now having taken a car, there would be a normal usage of that vehicle. So when I'm using that vehicle, there is also a loss of the value in that of the car which I'm using. Maybe I can say that wear and tear. A simple example I'll give you. Because of the usage of my car, especially take in that even very specifically tires. Now, because of my usage of that car, the tire may get bald, the tire may become weakened, the tires may become, the sole of the tire may become lessened. Now, can I go run down after the sole is over? That is, when the tire has become bald and becomes unfit for its use, can I go to the insurance company and say that my tire has gone out and you pay me for insurance on my tire so that I can have a new tire, replace my new tire on it? Or maybe because of usage, the tubes may get punctured. Can you go run down and ask for the puncturing expenses what has been incurred from the usage of that motor vehicle? No. So that is the reason why we say that what is excluded from that of the insurance of motor vehicle is the normal wear and tear. What could be incurred on that vehicle is excluded. The second one is where if a damage is caused to the vehicle of yours when driving by you or by any other person without a license. If a damage is being caused to your own vehicle or to the vehicle of others, then also the company cannot be made liable. Or where if a damage is caused by you at the time of, damage is caused while driving at the time of that where you are under the influence of alcohol or under the drugs, then the company is not liable. Or damage caused due to that of war. No, it is not liable. So in these cases, my friends, we shall see that there is an exclusion on the part of the company to indemnify you for the losses what is being caused. So in this way, my friends, we can see that the motor vehicles insurance, they would be covering all these areas and the areas of those motor vehicles which we are using with. But of all these things what we see, one important thing that could be asked for your short notes, compulsory insurance or compulsory policy. What is this compulsory insurance? When you are required to take a compulsory policy. See friends, we have understood now, just now while discussing with the types of policy, we have act only policy, third party policy, comprehensive policy. When we have these kinds of policies, these policies are very important to be understood. And also, especially I told you that these two policies are compulsory in nature, you have to obtain. That is the reason why we call it as it is a mandatory in nature on that of a person. That is, whenever when a owner takes up the policy, when he takes up the new vehicle, it becomes necessary for the owner to have that vehicle only with the policy outside. So it is something we call it as a compulsory insurance, which covers the passenger, the driver who is driving the vehicle, or it also covers the third party who is driving, who is going to be involved by this of the accident. So this becomes necessary for that. So in a way we can say that the owner of the vehicle has to take compulsory policy. Sometimes it so happens like, suppose if I don't take, what happens? What would happen if I am not taking the policy, insurance policy on my vehicle? See, tomorrow, because of the reason that the owner has not taken the vehicle, he may become liable personally for that of the loss or injury that could have caused to that of other person. And when he becomes liable for that of the loss or injury that has been caused, it may result in such a way that the claims what the third party could make up against this person may not be able to satisfy the claim of them. And when I am unable to satisfy the claim of him, then it may be difficult for the person that is for the third party that to lead his life. Maybe the dependence of that may lead to lead their life. It may become very difficult. See, suppose say if a person is earning about 50 lakhs rupees or say 10 lakhs rupees per year, and when an occurrence or the eventuality has taken place, maybe what the government or the company can do or pay, GIC can pay, is the General Insurance Corporation can pay, is that maybe it can pay to an extent of 50,000. Is it possible for the family to maintain with that 50,000? No. So it becomes very difficult, so that in cases of where if no insurance has been made, so that makes it necessary that you have to have a compulsory insurance. Or also vice versa, if you look in, suppose say I might be good enough to maintain my family, but in the course of this accident I am required to pay 10 lakh of rupees to third party, and I only own 10 lakh of rupees with all to putting together with all my property, including my earnings, my property, whether movable or removable, all those kinds of property comes only 10 lakhs of rupees. So it comes to 10 lakh of rupees and I am liable to pay 10 lakhs of rupees. What would happen? If entire 10 lakhs goes away, then where would I go? Maybe I might have caused the accident, but even not only me, my person who is being dependent on me, my family who is depending on me shall also become liable on that. So more of a cases we see that is the liability to that of a person becomes more of a penalty rather than compensating the person. So in that notion we say this compulsory insurance has become very important. And even the courts will, the authorities will not accept the policy, that is, they will not accept your tax on the vehicle unless the insurance policy is being paid with. So there is a statutory compulsion on you, my friends, that is to benefit the large number of persons, to protect the interest of the lives of the person, especially with that of the automobile accidents, or the effect that has been caused with the disability, or the resultant has caused with the disability on that of a person. It has become necessary that there shall be a insurance on those vehicles. So today what we understand here is this, my friends, compulsory insurance has become an indispensable on those of the vehicles. It has become indispensable. That's why we see this compulsory insurance is being made as a separate chapter under, that is chapter 11 under the Motor Vehicles Act, because of the importance that what we understand in respect of those insurances. That is, especially when I am to take with the insurance for my motor vehicle, how far it is necessary to just put you across with that, understanding the importance. I'm just giving in another way, logically I'm putting this across, that is understanding the importance of it. It has been made as a separate chapter, that is chapter 11 under the Motor Vehicles Act 1988, so that the provision of compulsory insurance is just made to protect, basically protect the third party rights. That is, when a person is involved in the accident, then that person should be compensated for the loss what is being caused by the act of me. Forget about if I am losing, fine, because of my default I have committed, but for no fault of the person, for no reason, that because of my act the person has to take an injury. So when that comes in, it becomes difficult. So at least to protect him, my friends, we shall see this, the third compulsory insurance has been brought in. In fact, in Sohan Lal Pasi versus Shesha Reddy and others, the Supreme Court makes an observation like this and speaks with the importance of this motor vehicle insurance, the two particularly with the compulsory insurance. It made its observation and made a remarkable observation, I can say, and also noting on this is that the road accidents in India has touched to its heights, especially in cities, he says. His Lordship says like this. especially in cities. The road accident has reached to the heights, and out of these road accidents, the majority of the persons who is involved in is the innocent people. And innocent people or persons have become the victims of this accidents, and if the insurance is not there, what would happen to these innocent people? And that makes an importance to have a compulsory insurance on all vehicle is necessary. So there is said that compulsory insurance is one such thing which you cannot take away, which you cannot put away or delete from that of the insurance sector, because it is the primary source where it would hack to the welfare of the people. Not only for that of the injured person, but also to himself. So that becomes necessary for us to understand what a compulsory license is. And one more beautiful question comes here is, can the insurance company become liable where the vehicle is put for the criminal use? I'm not saying when it is used for criminal purpose. I'm not saying. When it is put for criminal use, when it is taken for a criminal use, then can the insurance company become liable? Look at this. A very interesting issue was taken before the court. That was especially in case of Hardy versus MIB. Hardy versus MIB. The question is this: can a person claim an insurance, that is the amount of compensation, wherein if the vehicle is used for the criminal purpose or criminal activity purpose? An interesting case is this, my friends. See, in a yard, a security officer, while he was going on a check of the area, he comes to a notice that one vehicle is standing there, and with a presumption, with a doubt in his mind, finding something fishy there, he proceeds to, that security officer or the security guard proceeds towards the van, that is that vehicle, for making an enquiry and to test to ascertain himself that whether the vehicle was a stolen one or not. And when he was making an inquiry, usually the practice is because the person would be sitting little down than the person who is standing up. So he bends towards himself, hold his vehicle, that is his arms on the door of the van, and starts speaking to the person, that is the driver and the other co-passengers who are sitting in the van. When he was speaking, that is when he was making his enquiry as to the whereabouts of those person and of the vehicle, the person, in a fit of hurry to escape, what it does is that is he was using this vehicle for the stealing purpose or to steal out certain products, producers of that yard. In order to escape from that of the enquiry and the catching hold by the security guard, he drives the vehicle very fast. As a result of this, the security officer is also dragged along with the vehicle for few hundred meters, and thereby causing a severe injury on that of the part of the body of the security officer. Now, because of this accident, because of the injury, severe injury that has caused to the security officer, he was admitted to the hospital, and that is incurrence of expenses was being made in. Now, when it came to the question of suitably compensating for all those medical expenses and the loss what has been caused to that of the security officer, the insurance company denied to pay the insurance for the reason that this vehicle was used for the criminal purpose. And when it is used for the criminal purpose, the company cannot be made liable. So in that situation, my friends, it was observed like this, that when the company uses the vehicle for the criminal purpose, sole in itself would not be a criteria wherein the income, that is, the insurance company can go escaping out its liability. And there the court said that even where if the vehicle is used for a criminal activity, but the resultant of the use of criminal activity results into a loss or damage to that of the person, then the same shall be protected with. And accordingly, the court said that there was no deliberate action on the part of the act of the driver, though there was a deliberate action on the part of the driver, but that has no relevance to that of the person who is been affected with or inflicted with the loss or damages. Then the insurance should cover even to that area also. Likewise, I can give you one more example of this. Suppose, say, a smuggling is going on. The police comes to know, that is naval police or naval forces comes to know that the smuggling is being done by this car or cruise. What they do is that they take away, they will be chasing this cruise. So in a fit of hurry, what the cruise does is that it's another boat there. As a result, causes an injury to several persons who are there in the boat. Now, is that not the duty of the insurance company to pay the damages for them? It becomes the liability on the part of insurance. So, in this way, my friends, we see that the liability is not just to that of one's own mistake of you, or when you yourself are doing, or when it is being driven by that of any other person, that is by the employee, but also where the vehicle is being put into use of criminal purpose, then also we shall say that the insurance company becomes liable. Likewise, the owner also has an option of taking the other risks. See, it is not just that what is going to be made with, or what is going to be affected, or what the damages or loss is going to be caused with. If the owner wish for covering the other areas also, that is, if the owner wish to pay more premium for the risk, something like the loss or damage to that one's own vehicle, whether the damage is to be caused, whether the loss or damage is going to be caused by way of fire, theft, or by any other accident, etc., etc., he shall also have a right to take even for those risks. That is, if at any time, if the resultant leads down to the death or permanent disability of the person by any such theft or by way of a damage caused to that of a vehicle, then also you can go with. Suppose, say, I have parked my vehicle under the shed, and at the time of leaving my vehicle, the shed collapses. It is not an accident that I have committed, but because of the injury, because of the destruction of that shed or collapse of that shed, I might have caused injury, my vehicle might have damaged. In that circumstances, my friends, we shall see that the company is liable. And moreover than this, we shall also see this insurance will also extend to even to the pillion riders, especially in two-wheelers. See, a simple example I will give you. Suppose, say, while just going number, because this is of a pandemic season, a pandemic situation wherein we are coming across, we always try to drop somebody. But usually the practices of Indians, because we are, especially the people of Karnataka I am speaking, but of course I do believe that my other friends of my neighboring states and other parts of this country, states of this country also does the same thing. It is an experience of everyone. So what we do is that whenever when any person stops me when I am riding my two-wheeler, asking me for a drop so that I can draw me, especially in the summer season, people will get dehydrated and they feel very tiresome of walking. So if somebody asks me for, that too, especially a school kid, when they comes and asks me for a drop to the school, which is on my way, nobody would ignore that. Nobody would say no unless some exterior circumstances are there on his part. So in that case, if I drop some person, if I pick up some person who is willing to me have a drop, and if an accident is caused, what happens? Whether that pillion driver is an insurable person, or whether that pillion rider has any insurable interest in the claim, that of the vehicle, he is purely a third party. So in that cases too, it says that even a pillion rider is brought within the ambit of this. So he do also have an right of claiming the compensation. So when it comes to the claim of compensation, my friends, when it comes to the claimant issue, the main purpose of the rule is to be always looked with. That's what the courts have quite number of times. It has made its observation. It's saying this, That is, whenever when any insurance claims comes before the court, then the courts are required to look with the main object of which the insurance was being made. And only looking down to the main object of which the insurance, you have to satisfy yourself and then go upon for having issuing a compensation. I'll again take to a beautiful case here. That is in case of Nataraja BV versus Oriental Insurance Company, Asan. Asan's case it is. 1996 Supreme Court. See, Mr. Nataraju had insured his Tata Mercedes carriage vehicle, that is, it was called as Tata Mercedes Benz vehicle, that is truck it was in fact. He insured this vehicle under the policy, that is with Oriental Insurance Company, saying that this truck would be used for the purpose of a carriage of goods, that is for carrying the goods. And there was one small condition saying that along with your carriage of goods, the owner shall not allow, or the truck shall not carry more than 6 employees at a time. More than 6 employees. And of course, with this small condition, it was given to the truck was used for the purpose. But one unfortunate day, the company or the carriage of this vehicle required little more persons to be carried out along with the goods, because to deliver the goods and for lifting and carrying out the supply of those goods. So it took 9 passengers on that day. And to the unfortunate of that day, the truck collided with another, resulted into the damage and injury of those persons who were also in which it was carrying out with. Now, once when there was an accident, as usually the compensation was sought before the insurance company, and the insurance company denied to pay this money. That is, on the ground saying that there was 3 more excess passenger which the vehicle was carrying, and there was 3 more excess passenger vehicle, the company is not liable to pay. The matter goes before till the Supreme Court, and there the Supreme Court again makes his observation saying this. See, whenever when the court deciding upon the insurance, paying a compensation or awarding a compensation to the person, it should look down to the main purpose of which the insurance is effected with. And it made an observation saying that where if the denial on your part or observation to follow certain things, if they are not fundamental in nature, if they are not a fundamental breach what you have committed with, then those things should be ignored by the insurance company. And taking this, carrying 3 more passengers, I think for a truck of Mercedes Benz, carrying 3 more passengers in extra will not in any way be so heavy for the truck to go on with or to have a collision with, where it does not make you uncomfortable in your driving. So there the court says this, it makes an observation. Carrying 3 more passengers in addition to that of the 6 is not a fundamental breach that what the truck driver has committed, or it was not being put into it. See, the misuse of vehicle, well, it was just irregular. There was no fundamental breach. It was just an irregular. And being not a fundamental in nature, you cannot put an end to the contract. That's what it said to the insurance. You cannot put an end. Unless there is a fundamental breach, you could not do so on this regard. So, in this way, my friends, we shall see that whenever when the claim of insurance comes in before the court with MVC, you should always take it in a liberal manner, because it is always the persons who are affected would be going out of their hands if that is being taken. So, it should be seen that whether it is a fundamental breach or whether there is a fundamental deviation taken place in respect of your claim what you are making. So, in this line, it said that yes, the company was liable. So, this is one, we see that, my friends, as how the claim can be made in respect of motor vehicles claim. The second comes after this is, what is the kind of liability you can come in? See, when it comes to the kind of liability, friends, we can see that the liability can be in several ways. One is absolute liability. The second one is no fault liability, or the liability in case of hit and run cases. We can come across in this manner, my friends. In fact, in a comprehensive policy what we are having, the motor vehicle which has been covered under the insurance usually covers two kinds of a risk, that too with two types of principle. And that those two principles, that is especially with the liability, is one is knock for knock agreement and the other one is no fault liability. I repeat this. Knock for knock agreement, and no fault liability. Fault liability. Look at this. See, my major concern is with this, my friends. I'll be discussing majorly with this. But just let me say what is knock for knock agreement 2. See, two kinds of liability, again I repeat. Absolute liability, that is the absolute liability is where in case of any accident is incurred with, the members becomes completely liable. If an insurance is availed, they are personally liable to it. That is what we call it as an absolute liability. But when it comes to knock agreement, this is a kind of an agreement. Suppose say, if two vehicles, a car driven from Bangalore moving towards Mysuru, when it is moving towards Mysore, a car from Mysore to Bangalore traveling meets with an accident. Maybe because of the negligent act or because of the cautious act or whatever, the accident is caused. Now, because of this accident, there is a damage caused to that of a passer who is passing on the road. Now, two vehicles are there, car from Bangalore and car from Mysore. Two vehicles are there. So in that case, who should be liable? Because of the fault of these two cars, the third party is injured. The person who is being caused with the injury, loss or damage, maybe to property or to himself. Now, if your case is a knock-to-knock agreement, then in such case, both these two companies, the company which has issued a premium, a insurance on this car, a company which has issued a premium on this car, shall come together and pay the compensation. That is what we call it as knock-to-knock agreement. That is where both the parties shall settle out and pay the compensation what is going to be incurred with. This is one way we see it. But the other side we also see this, that is no fault liability. This is important, we should understand. What is this no fault liability? For the fault of me, I am liable, yes, I agree with. But for the no fault of me, why should I be liable? Mind this, my friends. Again I say, this is a piece of legislation which has brought in for the benefit of people, for the welfare of people, for the betterment of people. So, probably I can say, this is one such area which speaks with the same thing, In fact, section 146 clause 1, then I am speaking to you with, prohibits the use of any vehicle unless where the vehicle is without insurance. Motor Vehicles Act says 146 clause 1 prohibits the thing. And as I said to you just now, this motor vehicle legislation itself is a beneficial legislation. Being a beneficial legislation, no fault liability, which is defined under section 140 or provided under section 140, I don't say defined, provided under section 140, says that any person, that is, that person who is involved in the accident can be made liable for such sum of money without a fault entered by him and to the compensation what is arising out of it. I might not be at the fault. Suppose, say, a simple example I'll give you. I'm working in the factory and some Y or A, B, C are also working in the same factory. And because of that, because of the wrongful act or negligent act or lethargic act committed by this A, B, C have incurred a damage. I have inflicted with the injury. Now, when I am inflicted with the injury, what is the owner liable to? Has owner done anything by his conduct? No. You would have taken everything. Unlike in Factories Act, what all the precautions that is been required to take with, everything has been completely taken with. But still, the owner can be made liable. And when the owner has been made liable, to what liability he stands with? That's what we call it as a no fault liability. The same way even in motor vehicles also. See, it says that even for the no mistake of mine, suppose say, for example, I am driving with a great precaution, everything have been driven with. A person, just a cycle wala, without having looking to the either side of the road, just drags me and he himself collides me with my vehicle, resultant into death of that vehicle, or resultant into the death of that person and damage to the vehicle. Sorry. Now, for no fault of mine, should I be made liable? This is the issue we say. So, it says like this, my friends, when the question of no fault liability comes before the court, before the tribunal, of course the tribunal has a part in this discussing well. This tribunal can look into, because it says that very object of the legislation is this, my friends. The object of the legislation, in fact, we can say that it is the legislation is something, a measurable legislation in the terms of social justice. And it is just framed, the legislation is framed to meet the extent of responsibility that what a person owes to the society. It is framed in such a way to provide a social justice, to meet the necessity of the society that could be caused in the road accident. So in this sense, if you look upon where this is no fault liability is one such piece of legislation which speaks on that, which speaks with the social justice and say that this is in case of no liability on your part, but still you can be made liable for such amount of compensation. So that as a resultant, I was giving you a cycle wala just drags himself without looking the other side of this. If he just comes and falls on your vehicle by causing a loss, by causing a death of himself, then what would happen to that of the spouse of him? What would happen to the dependents of him? So some measurable relief should be given to him. For that, my friends, we shall see that no fault liability is being brought in. So that is why we say this, my friends, that is any person who has caused a loss, who has caused a damage, or a person which has resulted into death, or in case of permanent disability, then this could have been met immediately without showing any burden of establishing any negligence on the other part. If a person is negligent, or if I establish that the person is wrongfully acted upon, then I am entitled for an insurance. But if I can prove it before the court that there was no negligence on him, but still the occurrences has happened with, then I might be or I will be entitled to a compensation of this, my friends. That is, in case of death, two things we see. In case of death, a person is entitled to 50,000 of compensation. In case of permanent disability, I am entitled to a compensation of 25,000. That is, the owner of the company, owner of the vehicle can be made for this, so or the General Insurance Corporation would take upon with this if that is not the case. So the owner of the vehicle can be made liable even though where there is no wrongful act on his part, even though where there is no negligent act on his part or any defaulting act on the part of the owner. And this claim of compensation will not defeat or reduce any compensation or any question of compensation which he may have recovered from that of the company. Anything it could be. Suppose say if I am the employee who is employed under workman's compensation and I am also entitled for workman's compensation because of this accident, then by taking this amount of money will not reduce my right of claim of compensation under the Workmen's Compensation Act also. So this provision, my friends, alternative forum, that is what we see is that it is the code has a complete machinery on this. The provision provides for a complete machinery and says that in cases of any no fault liability, the jurisdiction is conferred on the tribunal, and tribunal shall have a power to exercise upon with this. So in this way, my friends, we shall see that the claim can be made upon with. So in this form, we can come across with what is knock to knock agreement, and more importantly, the no fault liability. And I repeat this, no fault liability can be asked for your short notes in the examination. Proceeding further, the next issue I'll be discussing to you is the tribunal, that is adjudicating body. The first half adjudicating body I would like to go is the tribunal. What is this tribunal? Sorry, before that, let me also speak to you with one more issue here, that is hit and run case. Before I get into the tribunal, sorry for that. See, what is in case of compensation by hit and run cases? Section 161 and 162 of the Motor Vehicle Act speaks with. This is something similar to that of no fault liability, I can say. What is hit and run case? Again, this could be a subject of short notes. See, where hit and run accident means an accident arising out of the use of motor vehicle, under quote use of the motor vehicle, where the identity of that vehicle cannot be ascertained in spite of the reasonable effort. I repeat this, where the identity of that vehicle cannot be established even or in spite of the reasonable effort that has been made in this purpose, and if the injury is caused to that of the vehicle, then we shall say it is an hit and run case vehicle. That's what under section 161 subclass 1 subclass B says, that in such hit and run case, a person is entitled to a compensation which as a resultant of such accident, and this should be provided by the general insurance company or any other such body which is carrying under the scheme of this insurance. I repeat this, that is, it shall be, that is, the person who are entitled to a compensation under the General Insurance Corporation of India, or where any company which is carrying the business of general insurances recognized shall be payable for this compensation. And we call this to be as a statutory compensation which is payable by that of the person. Now, what is the statutory compensation that is going to be paid here is that it is in case of such hit and run case, the statutory compensation in case of death, it is 25,000, and in case of permanent injury, it is 12,500. It is 15,000 or 12,500. 12,500 it is. Half of the area, that's fine. So, this amount shall be paid by way of compensation in cases of hit and run case. So this is a statutory compensation which has been allowed. That is, this was brought by the Amendment Act of 1994. Said that this amount has to be paid. Then it was before 1994, it was very less, but now it is this amount. However, we see that today it is because of an hit and run case that nobody has found and no identity has been made. Tomorrow it comes to say that the vehicle has been traced. Maybe after 1 year or 2 hours, the vehicle has been traced. Now, when the vehicle has been traced, I go for a claim against the person, against that insurance company, or against such person. And there, if I have got the claim of 5 lakhs of rupees from that of the hit and run case, that is because of the injury that has been caused by the vehicle, then that amount what has been paid here shall be entitled to be deducted with. They are entitled to have a deduction from out of this 5 lakhs, but in case of no fault liability, there is no such deduction. That is, you cannot compensate or you cannot take away the money of what is already been paid with. That has no relevancy. But here, when it comes to hit and run case, it can be deducted with. So the application, when we go with the cases of hit and run case, where if it is still pending before the court, and if it is still an authority wherein I can show forward that there are particulars of the compensation so awarded, in that time also the same can be deducted from that of the amount. So in this way, my friends, we can see in cases of hit and run cases, they are also entitled for a compensation by the department. That is by GIC or any other general insurance company which they are carrying the business of the same. So this is one we can say with. Now let me come down to the tribunal, that is the adjudicating bodies. Basically, when it comes to the adjudicating body, we see three adjudicating bodies are there. In fact, I can say you, by hierarchy you can say Supreme Court is the adjudicating body, High Court is the adjudicating body, this is at one level, but at the lower level we have a tribunal and Lok Adalat, and of course then we also had a consumer courts. Consumer courts we had, but now it is now. Let me go with this. First let me speak to, of course this is only in case of appeal, and again this is again in the form of appeal. First appeal or on appeal which is being preferred under the certificate or so, or under the special leave petition will be going to the Supreme Court. But rest of that, when you look how it is before the tribunal, what are the powers of the tribunal, how would this adjudicating authority go with? In fact, my friends, section 1110 A to F deals with this. Deals with this. Now what is this? See, when it comes to a body as such which is going to decide upon with, in fact the central government, it is of course in relation to that of the disposal of the cases of the motor vehicles claim, the central government have come up with the constitution and providing a functions to the tribunal which has brought from 10th February 1957. 1957. It has, sorry, it is not 10th, 16th February, sorry, from 16th February. 16th February. It has brought into force. The only object of having establishing this tribunal is to provide a speedy, cheap and effective mode of delivering a justice in respect of the motor vehicle claims. We can say like this, my friends, tribunal in fact, or tribunal we call it as, in fact is an alternative forum which has formed into a complete machinery to try and dispose the matter with respect to any motor vehicles claim. And I was saying you with this, as far as the no fault liability is concerned, the jurisdiction is again conferred with this tribunal. Then also I was saying it is conferred with the tribunal, and tribunal shall have a power to exercise its power even in cases of no fault liability. However, section 175 of the Motor Vehicle Act bars the powers of the Supreme Court from exercising its jurisdiction. It bars, that's why we say it is expressly barred upon the civil courts to exercise its power in respect of any motor vehicle claims. So, the tribunal shall be constituted as accordingly, as I said, on 16th Feb 1957 it was brought into, and for the purpose of trying and disposing the matter, the tribunal has come up with, the tribunal has been constituted to try and decide the matter, and it is the state government shall, as it thinks fit, may constitute such number of tribunals as it is necessary, consisting of one or more other members of this tribunal. But the state government, when it appoints two or more members, then one among them of such member will be the chairman of that tribunal, if it appoints more than one person or so. And what are the qualifications of this person, that is the members? That is usually senior most would become the chairman of that thing. And the qualification for this is that the member, especially a judicial person who is there, would be a person who would have been a judge of the district court or high court, or where is qualified to become a judge or for the appointment of a judge of the district court or high court, shall be the member of this tribunal. So only such person, a judicial member, can be appointed, and he shall be made as a member of that tribunal, and one among them would be the chairman of this. And the powers, if you look, the duties, if you look about this tribunal, is that the tribunal shall have a power to decide upon all those petitions which is being made before, it shall have a duty bound to find out that whether the prima facie case is being made out by way of petition before, to look into whether the accident has been caused, whether the accident is by a resultant of motor vehicle, whether the parties herein who have come have sustained injuries, whether they are in the past cause, that is whether the causing of that accident has resulted into a permanent injury or death, or also we see that whether the vehicle to which they have come out with was the vehicle which has involved in the accident or not. All these things, with respect to all these things, we shall see that the tribunal has a power to decide upon with. And as I then said to you, well, this is an adjudicating body to decide upon with the cases with relating to that of motor vehicle claims. We shall see this, my friends, that being an adjudicating body resulted out it has a power to decide out or to determine upon with that whether the injury resulted to that of a person is a permanent disability or partial disability, whether the resultant is led to the person to the death or not. All these things I was saying you with the example. Suppose, say, I have been incurred with an accident, or I have been put in an, I meet with an accident, and having met with an accident, I am hospitalized. I was yesterday in my previous slide, I was speaking to you with this discussion. I meet with an accident and I am being hospitalized in the hospital, wherein if I am affected with pneumonia, and thereby because of pneumonia I dies. Now it is the tribunal who has a power to decide, to say that whether the death caused by you was because of the accident or because of the infection which has caused you in the form of pneumonia. It is for them to decide. So it is for him to decide. So these powers are there. As I was saying you with this, however, section 175 imposes or bars the powers of the civil court from exercising its power jurisdiction on this. But still, my friends, when it comes to the procedure of entertaining the motor vehicle claims, we shall see that the tribunal shall have a way to adopt all those procedures of what the civil court would adopt in. It has a way to adopt, like maybe something like for issuing issuing a notice or causing notice to the opposite party, giving an opportunity to that of the opposite party, hearing of both the parties, or conducting an inquiry into the matter, or pass any suitable award in between, pass interim awards in this between, or shall also determine the sufficiency of the amount that is going to be paid, or it could be saying that whether the jurisdiction comes within the area or not. All these things, and sometimes even it may question upon with the powers of the authorities who have filed a panchanama before the court, and it may also call upon for filing a legible copy of the FIR if it has not been properly made. It can also subject for an inquiry and conduct and witnesses of those who are to be an witnesses of this accident. All these things, all those powers that what the civil court would do follow can also be followed here. And more of a thing I would like to prove here is this, my friends. Usually when a dispute is going to be settled by the tribunal, or if it is going to hear by the tribunal, it is in the form of summary procedure the tribunal will put in. That is, the courts are required, the tribunal is required to follow the summary procedure. Strict provisions cannot be insisted upon. But unlike when I say civil courts, certain provisions are required to be followed, but that such strict provisions need not have to be insisted. Certified copies of FIR, inspection map, site visit or site inspection memo, we call it as, panchanama, inquiry report, post-mortem report, and all other documents which is required to be can be submitted before. They can call the police officer or doctor to the tribunal and call upon for their formal inquiry to produce a formal proof on this. All this, my friends, are the powers which can be exercised by the tribunal. If needed, in some cases where if the tribunal feels it necessary that it requires an assistance of some expert or some known person who is in this area, can also call upon such person. They can take the assistance of such person to the effect of deciding the matter. And having looking into, the tribunal can also be satisfied that whether the resultant of this eventuality was occurred by way of an accident or not. They can record the same reason in writing, and then if it has been found that, then they can make that insurance company is liable or the owner is liable in respect of the claim what is being made. And in that case, after the award has been passed or after the adjudication is been made in this regard, the copy of such award shall be delivered to the person within 15 days of time of the passing of award. And in together with this, the tribunal shall also have a power to pass a simple interest on that of the award what it is going to be made. And also, my friends, they can also go for a compensatory cost which could be imposed against their opponent party. And when it is going to impose a compensatory cost of the opponent party, however, there is a restriction saying that such compensation or compensatory cost what is going to be awarded shall not be more than 1,000 of rupees for having proving that there was a false and vexatious claim or defense that has been taken up by the party. And against this, my friends, any person who has been aggrieved by the orders of this tribunal shall have a right to prefer before the High Court within 90 days from the date of the award that is being passed. So again, the matter can be taken and you can dispute it before the High Court. So my friends, in this way, the tribunal shall have a power. But where the tribunal has passed an award, if the powers are given to the collector shall have a right to collect all those dues, unlike whereas in cases of recovery of land revenue. In the same manner, the tribunal shall have a power to collect these things for the purpose of which the order is being made or the award is being made. So this is how the tribunal has come up and the functions of this tribunal. The next one is the another form of the system we call as the Lok Adalat. Friends, probably when you come to the final year of yours, you would be understanding and you would be reading the Lok Adalat and importance of the every claim to be made between the mediation centers. Section 89 would speak on that anyway. But here also we see the very object of bringing the tribunal was to have a speedy delivery of justice system. They wanted to have that's why how we say that summary proceedings used to be required to be adopted by the tribunal. And through this summary proceedings, they have to dispose of the cases, and the person who is being affected by this or who have resulted from that eventuality should be quickly be compensated so as to take his life in a normal way. But unfortunately, though the object of which the tribunal was brought in, this was not able to be achieved with, because of the reason that the enormous cases are increased in the vehicle and also in the accident. And it is told that every day in Bengaluru itself, there are more than 10,000 of vehicles which are going to be registered. New vehicles are going to be registered. Imagine what is the growth that it has been taking place with. The number of vehicles are playing, it has become more, and as you see, it is something like this. The more the population, the death is also more. The same way. That's how we look upon with. So when there was number of cases which started coming in, the tribunal has become overburdened with. And the object of giving a speedy delivery system was not able to be satisfied out with. As a result of this, my friends, as there was an increase in all types of litigation and various legal services could not be provided to the person, in that scenario we see that in the year 1987, a system was brought in called to be as Legal Services Authority, where this Legal Services Authority in fact came in a way which that is as passed, and the enactment was passed by the parliament, and this came in a way of settling out the disputes what could have between the insurer and the insured. or the insurer and the third parties. So this system is a way in which it came out by in deciding upon the disputes relating to any motor vehicle claims. It said that if you have a dispute and that cannot be settled upon with, then there shall be a compromise entered into, or the authority would proceed in settling out the matters and transfer the same after disposal to the tribunal for its confirmation. So in this manner, my friends, the authority came with an inclination of having settling out, that is outside the court system, and it is in fact we can say that it is one such step which the Lok Adalat have come up to, which is parallel to that of the disposal of the cases by that of tribunal. That is the authority intends to regulate the courts and run the courts, especially in the matters. Mind this, the application, as far as the application to hit and run cases are concerned, as there is a fixed compensation which is being made by the person, the tribunal has no power to decide with this. And once when the tribunal has no power, the Adalat also has no power to decide upon with that. So in all those hit and run cases, it has no power. But apart of this, my friends, the tribunal goes parallelly working out with the Lok Adalat goes parallelly working out with the tribunal, and the tribunal can decide upon. Even in cases of no fault liability, the tribunal can look upon with this. So in this way, my friends, we can see that the tribunal and Lok Adalats are working together. But when it comes to the consumer courts, today, friends, consumer courts are not working on this. No claim, that is in cases of MVC petitions, the consumer courts have no role to play with, because of the reason that, my friends, today we see that, of course, let me put it in this way, sorry for this, my friends. After the Amendment Act of 1995, when the tribunal was brought in, when the enactment was amended with, it said that tribunal has no, that is the consumer courts have no power to decide upon with. And here it says this, that is amending the Act by Amendment Act of 1995 to the Act of 1988, it said that when there is a special body which has been constituted, or special enactment has been made and a special body which has been constituted, or special courts or judicial setup is been made out with or established with, then the other courts or normal courts will have no authority to decide upon the matter. And usually we say like this, my friends, when the special legislation is framed, giving out a body, such a particular body to decide upon the matter of a particular claim, then that special legislation will always override the other legislation. And the body which has been constituted will be the sole body to decide upon any dispute relating thereto. So in that scenario, we shall see that this special legislation would always prevail over the general law, and by reason of this, the applicability of the Consumer Protection Act now is taken away in respect. Because one of the simple question which you used to always come before is that for the deficiency of service. Because they are under Consumer Protection Act, they have come up saying that what is service and what is that you are right before the consumer tribunal or consumer courts for, that is the body when there is a deficiency of service. So if there is a deficiency, usually they used to come and say that because of the deficiency, look at this vehicle driver has not drove his vehicle properly, there is a deficiency of service in carrying out my carriages, so in that reason he should be made liable under the consumer protection. This was taken away and said that from therein after, it said that is after the Amendment Act of 1995, when there was a particular provision provided to decide upon the matter of MVCs are concerned, it said that the consumer courts have no power to decide upon the matter. That's what the Supreme Court have also said in Tiruvannallur Transportation Corporation Limited versus Consumer Protection Council 1995 case. This has led down to the amendment also, where the court said that and the compensation, that is, it said that any compensation arising out of the use of motor vehicle cannot be adjudicated by the commissions, that is the consumer courts or consumer commissions. and any redressal of this, that is before redressing the consumer grievances. And there it said that is whenever when a complaint has been filed before the consumer forum for the deficiency of service, then if that in a way falls within the tribunal with respect to motor vehicles claim and the claim has been made, then this consumer courts have no power to decide except that of the services which is involved in. Suppose say if I am transporting the goods, maybe while transporting the goods in my carriage or in my carrier, if I have caused the damage to that of my goods which I am carrying, well, maybe I may be held liable. Maybe you can hold me liable for that matter. But when it comes to the claim resulting out of the use of motor vehicle, that is exterior, not by the interior goods, then it is always the tribunal, or that could be also settled in local, and consumer courts have no power to decide upon with this. So in this way, my friends, we shall see that the consumer courts today have no jurisdiction to decide upon the matter of any motor vehicles claim. And how assessment of compensation is going to be made? Have repeatedly the courts have said, and even I was also addressing on the same discussion. See, whenever when it comes to the question of the assessment as how the compensation should be awarded with, the tribunal, the High Court, the Supreme Court have always said that a liberal approach has to be taken in, especially in case of awarding the compensation. Sometimes it said the amount what you are going to award might be greater than the claim what has been made. It might be, but you should always be liberal enough. Vice versa, it also spoke saying this. That is, while passing an order, that award what you are going to pass on the claim of what is being made by the petitioner therein should not be in the form of punitive in nature. It should not be something a burdensome on the part of a person. It should not be as a penalty which is being imposed against a person, because the duty of the motor vehicle legislation is not to impose a penalty, but to put certain amount or to just give certain amount of compensation what is being payable by you. And of course, only in cases of negligent act, some amount of penalty is being payable by you, can be harder to be paid with. But when the award that you are paying with, when you are passing with, that should not be punitive in nature. So also it said that when you pass an award or when you pass an order, then that should not be a source of profit for the person, that is to the victim or victim family. That is to be always due, it should be due, take care. The party should, that is the insurance company, nor the tribunal, nor the courts should take care in these aspects while passing an award. However, we see that there are certain criteria which are going to be assessed while awarding a compensation. That is, suppose say, if a person is deceased, then in case of deceased person, what is the expectation of a life of a person if he would have lived? Like, what is his age? What was his health condition? What was the possibility of his determination of life? So, taking average of all these things, we shall see that the person could have lived for these years, and by this living he would have earned this, and this could be the expenses what could be deducted out of it. One criteria. It would also look that the amount required for the future provision of their wife, like just estimating that what could be required. That is, if a person would have earned this is the amount, what could be the future provision that I can make for the purpose of providing the life for the dependents of that family. What would they have spent for the entire lifetime if the person would have been there? That amount. Calculation would be made on that. What is the annual income of a person who have lost the life by way of that accident? That would be multiplied with the number of years that he would have service into. That is equivalently, that would be taken into, that would be also one criteria. And a part of this, having calculating all these things, the deductions are also being taken place with. That is, if the deduction is in respect of that, if a widow is going to accrue certain amount by way of interest in the property of her or in property of another thing, then what is the amount? That amount can be deducted. The amount can also be deducted from all the possibilities of the wife, where if the wife is dying, that is what is the earlier time that which you could die. Suppose say, I might be fit enough to take the burden, and because of my death my wife has incurred, but my wife is not good enough. She might have lived only for 3 years or 4 years. I would have lived if I have, that is, though she is living, she would live only for 4 to 5 years, or because of her health condition. But if I would have lived, I would have lived at 20, 25, 30 years. So what is that? The expectancy of the living of the wife. And what if the husband and wife would have lived, and for what span of time they would have lived their life together? All this would be taken into consideration while ascertaining or assessing the value of this money, my friends. So it says that when the assessment of compensation comes in, it says the assessment of compensation should always be looked in the cases of injuries, something like that is in cases of death we see. But when it comes to the cases of injuries, what is the damages both to the person and property, what is the general damage and what is the special damages. That is how it is should be assessed with. What is the compensation for the personal injury that could be awarded? What is the compensation that could be paid for pain and sufferings? What is the compensation that could be awarded for the nervous shock or neurosis that could take place with? What is the liability for the psychiatric illness because of the shock that is involved in? Loss of amenities and enjoyment of life. I repeat this, very important. Usually the courts looks into, that is, loss of amenities and the enjoyment of life. Suppose say in the accident, if I have lost my 2 eyes, I have become blind, or I have lost my hand, or I have lost my 2 legs or 1 leg. What is the loss that I could estimate in this? Or what is the expectation of life that I would have, whether it is for a short life or for a long life. So all this is being taken in consideration while deciding with that of the assessment in cases of injury. So when it comes to a death of a deceased person, assessing the compensation in case of deceased person and assessment in case of injury varies to each other, my friends, difference with each other, and on the basis of these grounds the tribunal would assess upon and pass an order in respect of that compensation.